Hi guys, welcome back to Battle with Allah. This is Mujala Olua and I'm super thrilled to be here today. Today we want to talk about a very important case. This is a judicial decisions video and you know that I love judicial decisions. Especially so because today we're talking about Garba and University of Maiduguri. Garba and University of Maiduguri, if you have been following this channel for a while, you will know that it is one of my favorites because that's the first case that I ever analyzed as a law student. So I remember that in 100 level, I went to University of Ibadan and Professor Akintaya told us that, then Dr. Akintaya told us, oh, go to the library. That was our first law course, legal methods. He said, go to the library, get a law report and read up a case and summarize it basically. And then we were supposed to submit or give feedback in class. So I remember I just sauntered into the library. I did not often go to the law library at the time. And I'd run into a senior, Sister Tolu Adeyanju, now a senior at the bar as well. And I just told her, oh, Professor Akitaya said we should come to the library and read up a law case, blah, blah, blah. And she just handed me a law report and told me to read Garba University of Maiduguri. And I read it and I loved it. It was so simple, it was so easy for me to understand. And I have not forgotten since then. Of course, over the years, I've gone back to read it, to refresh my memory. But it's a very important and a very fantastic case because it is a case that shows that you can stand on your right and actually get what you want by the law, even if you're an underdog, because the students in that matter were underdogs, so to speak. It is also very important because it is a case that embodies fair hearing. We've talked Please watch the video that we did on fair hearing. I believe I recorded that video in 2021. Please look for it and watch it, or check the description box. I would try to remember to put a link to it. So Garba University of Maiduguri embodies fair hearing because it talks about Nemo Judex in Kausaswa, no one can be a judge in this case, and it talks about audio teran partem, that's hear the other party out. So we're going to delve into it, but let me summarize the case. I have a summary that I want to read out to you of the case. So the facts, let's try to use FIRAC because a law student message or mailed me recently and wanted to know how to answer law questions. The easiest way to answer law questions or scenario questions is to use FIRAC. We've done 2 videos on FIRAC on the channel, how to draft your brief using FIRAC and how to summarize a case using FIRAC. You can apply FIRAC to any legal scenario or problem. FIRAC is just facts, that's the F. So it's a mnemonic, F for facts, I for the issues or issues, R for the rule, A for the application, and C for conclusion. So the facts of Garba University of Maiduguri, a group of students who are the appellants, because this is an appeal decision, it's a Supreme Court decision that we're going to be talking about. Of course, we're going to talk about how it started at the trial court, because he went to the trial court, Garba and 8 other suspended students went to the trial court, the High Court of Borno State, and then they won, and then the school appealed to the Court of Appeal, the school won, and then they appealed to the Supreme Court, and then they won again. So a group of students, the appellants, were expelled from the University of Maiduguri for their involvement in a riot. The students claimed they were not given a fair hearing before their expulsion. That's the facts. Those are the facts. The issues now. Did the High Court have jurisdiction to hear the case? That's 1. Did the disciplinary board follow proper procedures? That's 2. Did the Court of Appeal correctly rule on the case? That's 3. Those are the issues before the Supreme Court to adjudicate upon. Now, the rule, of course, the rules are the rules of audio teran partem, the rules of Nemo Judex in Kausaswa, and the rules of jurisdiction. And then the application now, which is the judgment. The Supreme Court found that the students' fundamental right to a fair hearing was violated. The disciplinary board should have allowed the students to present their defense and challenge the evidence against them. The Court of Appeal was wrong not to send the case back to the High Court for a re-hearing. Now, that's the application of the rules. And of course, the conclusion is that universities should follow proper procedure in disciplining students. Students have a right to fair hearing, and the High Court is clothed with jurisdiction to hear all cases where there's been an infringement of fundamental human rights. So now, let's start from the beginning. What really happened in Garba and University of Maiduguri? the facts. On the 2nd of February 1983, there was a rampage on the campus of UNIMITE, that's University of Maiduguri in Borno State, Nigeria. So a certain Mr. Zadok, a student as well, with about 500 other students, started the riots around 9 p.m. in the evening of that day. So they marched to the VC's lodge, where they set the lodge on fire, destroyed things. They destroyed the main lodge, they destroyed the mosque, they destroyed about 6 cars, and a bicycle belonging to the VC's 5-year-old daughter. And they also went to the registrar's house, where they destroyed 3 cars. They went to the staff club where they looted about 33 cartons of beer. Then they went to the DVC administration's lodge. They went to the DVC academics lodge, where they destroyed things, looted and carted, away a number of things. Then they went to the school bookstore and they razed it down. And then they also went to a female lodge, Aisha Hostel, female student lodge, where they manhandled some female students, and left them in shameful conditions. It was a full-blown rampage. So that was on the 2nd. On the 9th, the VC then set up a disciplinary board to look into the matter and advise him properly. The VC also set up a panel of investigation to look into the matter. So the panel, conducted their hearing, invited the students, heard from the witnesses before it, and reached a conclusion that there was indeed, a rampage on the school premises, the residential area of the school premises, and all the places that I've earlier mentioned. They came to the conclusion that of the 500 students that started the rampage, less than 100 of them actually participated in the assaults, the arson, the willful destruction, and the looting that took place on that day. And so they recommended that those students be expelled. And the disciplinary board set up by the VC, adopted the investigation and the recommendations of the panel to advise the VC, and those students were expelled. Following the expulsion in March, Garba and about 8 others filed a suit to challenge the expulsion. Essentially, they were saying that, arson, willful destruction, assault, all those things are criminal matters, criminal offenses, and the school is not clothed with lawful power to adjudicate upon them. They were also claiming that they were not given an opportunity to defend themselves before the panel. They could not cross-examine the witnesses the school called, and they had alibis. All of them claimed that they were in their hostel or they were someplace else apart from the venue of the rampage. Their alibi were not investigated by the panel, and they were not allowed to bring their own witnesses to support their case before the panel. So they challenged the legality or otherwise of the school's decision. So at the High Court of Borno State. So they came before the High Court to say that because of those things that I have mentioned, that is, their alibi was not cross-checked. They were not allowed to defend themselves, to call witnesses or to cross-examine the witness of the university or the panel against them. They claimed that their fundamental rights had been breached, and then they asked the court to reverse or nullify the expulsion as because the proceedings that led up to it was a contravention of their fundamental human rights. So you see the principle of audi alteram partem. So hear the other party out. They were not heard by the panel. The panel just heard the university's witnesses and reached a conclusion without, entertaining their own defenses as should have been done. So the High Court decided that their fundamental rights had been breached and ordered that they be readmitted into University of Maiduguri to continue their education, and that they be made to just pay 160 naira, which is what every other student had to pay for the damages that were caused during the rampage. So the school was not pleased with this, so the school appealed the decision. Essentially, the school was arguing that the vice chancellor is clothed with power by the school laws to mete out discipline to students who had committed infractions according to the school's rules and regulations, and so he was clothed with this power, by virtue of his office, which is an appointment by the visitor, which is usually the governor in Nigeria of a state, or the president, So if it's a federal or state university, so the visitor had clothed him with that power to decide and to mete out discipline. And so he was acting in his rightful authority, so that the decision of the High Court should be overturned. The Court of Appeal agreed with them and held that the court could not strip the VC of his power to administer discipline in the school, and that students who are students of the school must learn to comply with the rules and regulations of the school. So it overturned the decision of the trial court, and then the students went on appeal to the Supreme Court, which is the final court in Nigeria. Essentially, the Court of Appeal was saying that, even if there's a likelihood of bias, or even if the trial court was holding that there's no fair hearing, what it should have done is refer the case back to the school to be retried, not to nullify what the school has decided, because the Deputy Vice Chancellor, who was also, accused of bias because, his house was burnt, the VC's house was burned, so it was like they were adjudicating in their own case. So those people, the Court of Appeal held that they were acting in their statutory capacity to enforce discipline in the school. So the trial court could not strip them of that power. Also, that the trial court could not decide who should be expelled and who should not be expelled, who should be a student of a university, that the school is solely clothed with power to do that, to decide that. So the decision of the trial court was, meddling with that power. So the Court of Appeal agreed with the school, and the Court of Appeal nullified the decision of the trial court. So Garba and 8 others went to the Supreme Court, which is the final court of the land. At the Supreme Court, the court held that the Court of Appeal erred, in law, as the appellants had put forward, and that fundamental right is inalienable and it must be respected by the legislature, by the executive, by all and sundry. The students had a fundamental right to fair hearing. You will find that in Section 36 of the 1999 Constitution of the Federal Republic of Nigeria. They had used the 1979 Constitution, but if you were reading it today, you will find the provisions of fair hearing, extensive provisions in Section 36. That's Chapter 4 of the Constitution. So the Supreme Court held that they were entitled to fair hearing, that the fundamental right is not a right to be a student, which the Court of Appeal was contending that the school had the exclusivity to decide, but a right to fair hearing before the panel. Then the Supreme Court also held that, the disciplinary board, which advised the Vice Chancellor on expelling the students, only adopted the decision or the findings of the disciplinary panel. It did not make a finding of its own. It did not make findings of its own. So it did not satisfy itself that the students were actually guilty of the allegations. 3, the Supreme Court held that only the court of law can decide crime. They are the only ones that can adjudicate on crime. So the school cannot decide who is guilty of arson or assault or willful destruction or whatnot. So only a court can determine criminal matters or criminal allegations. The Supreme Court also decided that whether the students were before the disciplinary panel or any other administrative body, the principles of fair hearing must be adhered to, which is nemo judexin causa sua and audi alteram partem, because they are constitutional provisions. They must be complied with. As such, even if they were not before a court of law, the fundamental right to fair hearing must be respected and protected. And so the Supreme Court allowed the appeal, nullified the decision of the Court of Appeal, and held that the students should be readmitted into University of Maiduguri and only be mandated to pay the 160 naira that other students paid for the destruction that was caused during the rampage. So there's a lot of lessons, a lot to unpack from this decision. There's we talk about fair hearing, we talk about fundamental rights and how it must be complied with across board because it's a constitutional provision We talk about the fact that the students knew their rights and wanted to see the case through, and they went all the way to the Supreme Court, which is very laudable and admirable. And we talk about the fact that the school, even while meting out discipline, which the courts will not prevent it from doing, must adhere to the constitutional provisions of audi alteram partem and nemo judex in causa sua. So if you're thinking of fair hearing, Garba University of Maiduguri is a fantastic case to back up or lend credence to that principle of law. Another important lesson to unpack is that guilt in criminal matters can only be decided by a court of law, after which it can be adopted and acted upon by an administrative tribunal. Recently I had to advise an administrative tribunal on something similar because, a court matter was ongoing in a disciplinary action, and then the administrative tribunal was also ongoing. So they were concerned that if the court matter should precede the conclusion of their own case, that it may nullify their proceedings. But I let them know that that's not the case. A prosecution of crimes is a separate endeavor, and then administrative fact-finding and decision-making, discipline enforcement is separate. The only thing is that if the court arrives at a decision, the administrative panel is at liberty to adopt that decision and enforce it. Law. Also, it is an instructive case for universities in Nigeria and universities in general to advise themselves properly in following proper procedure for enforcing discipline, on their campuses and in the establishment. Very important. So that's all I have for you. Let's continue the conversation in the comment section. I will see you in my very next video. Bring a friend to Battle with Ola. To-dos.